Okay, we are live and on the record.
Well, good afternoon and welcome to the appeals court. My name is Judge Desmond, and with me is Judge Sachs and Judge Grant, and we'll be the panel for your matter. This is the Department of Children and Families in another versus Mother in another, docket 2020 P1314. As you know, 15 minutes aside and no rebuttal. Will the department and child be splitting their time? How will you be splitting your time?
Your Honor, it's 8 minutes for the department, 7 minutes for the children.
Okay. Thank you very much. I think with that, we are ready to go. So Attorney Bernardi.
Thank you, Your Honor. Good afternoon, Justice Desmond, Justice Sachs, and Justice Grant. If it please the court, my name is Christine Bernardi, and I am counsel for the appellant mother. Mother appeals the judgment of the trial court finding her unfit, her children in need of care and protection, and terminating her parental right, and implores this court to remand the matter for a new trial. This is a termination of parental rights case like the hundreds of termination of parental rights cases tried in the Commonwealth of Massachusetts each year, in which minimal testimonial evidence is presented and a torrent of documents, in this case 644 pages worth, are entered into evidence replete with unattributed hearsay, opinions, judgment, and admissible statements of children, including those of sexual abuse, where the court, knowing such evidence is inadmissible, relies on it so heavily that the result, as is in here, is substantial.
Let me just stop you right there. When you say the court knows it's inadmissible, there was no objection to call any hearsay issue to the court's attention.
Your Honor, that is correct. That did happen. There was one motion in limine, but that was actually a motion in limine that was for the 72-hour hearing. It was not a motion in limine that was filed during the course of the trial. But I'm saying what my argument here today, Your Honor, is that even when, or despite the fact that the trial court attorney failed to object, the court took this evidence, knew the evidence was inadmissible, and still relied on that evidence. And majority of the evidence in this case that was presented regarding physical abuse, sexual abuse, domestic violence, mother's contact with the children, mother's contact with father, the majority of that evidence that laid the ground for the court's decision was inadmissible. And based on that fact, I say to the court that the judge's job is not to merely sit and not pay attention, but the judge is to look at the evidence and to say to themselves, geez, I'm a fact finder in this case. I'm not just somebody who stands by, and as part of my job, I should take into consideration the fact that there should be very little weight placed or no weight at all. I should not take into consideration this evidence.
So what do you point to specifically? Let's pick one thing.
One thing is, we'll start with the sexual abuse statements of the children. Children made statements of sexual abuse. The court relied very clearly on those statements of sexual abuse. And if I could just have a moment to get to those notes.
So while you're doing that, it's my understanding that neither of the children are alleging that they were sexually abused by mother. Is that right?
That's what the child's argument is in her brief. However, that is not the case in terms of what the court found in their findings of fact and conclusions of law. The court specifically made the finding of fact number 20 and finding of fact number 150 that the children had been sexually abused, as well as in her conclusions of law. She clearly states in conclusion of law number 16 and conclusion of law number 19 that the child had been sexually abused, and that she relied on that statement, on those statements. Even though previously, I think it's in finding of fact number 16, she says she's not taking it for the truth.
What statement is she relying on where the child is alleged sexual abuse at the hands of mother?
In finding of fact, if I could just have a moment.
Sure. I mean, I know there was some evidence about they were exposed to some videos perhaps, and engaged in some sexualized behavior, but
And the judge,
but not at the hands of mother, as I understand it. So let me just go back to my first question. What statement?
the judge inferred from those statements made by the children that they had been sexually abused by the mother. She makes that conclusion of law.
And you're saying that's not a fair inference, although the child didn't point directly to mother.
The judge states that it was mother who conducted the sexual abuse. She makes that conclusion. And no, that's not a fair conclusion.
What do you make of the judge's footnote 1 and the judge's findings and rulings, which cites to custody of Michelle and says exhibits were admitted in whole or in part. 51A reports were solely to set the stage. 51B reports were considered for statements of fact, not purposes of diagnosis. Does that footnote sort of save the judge's findings and that they were for proper purposes?
Your Honor, that is done on a regular and consistent basis in these cases. The judges make these statements, but the judge does not go and then strike out the evidence, each document, the deluge of documents that are in this case. She doesn't strike out that which is not primary fact, that which is setting the stage. So there's no way of telling which one she's relying upon and which one she doesn't. It's very clear from her findings that there's nothing in there that says that she struck anything out or that what she's not paying attention to. But she does clearly take into consideration in her findings, and she concludes in her conclusions of law that the sexual abuse occurs, as well as physical abuse. There's other statements that the children make to a number of different providers that the judge relies upon in regards to making a conclusion of law that the children had been physically abused.
So that's like they got paddled, I think was one of them. Is that correct?
Mm-hmm.
Or
Yes,
they're
Your Honor.
afraid that their mom's going to whip them.
Yes, Your Honor. And the judge concluded that mother had physically abused the children.
I have a question for you about the parenting evaluation from April 30th, 2018. It's at page 288 of volume 2 of the record appendix. Are you saying that this entire parenting evaluation wasn't admissible, or was it a court investigation report?
I'm saying this entire evaluation is not admissible. It's not a court investigation. It's not evidence under section 21 or section 24, which Luke talks about, right? Luke says, or Luck, I'm not sure how one says it, but Luck says that section 21 reports, section 24 reports, which section 21 reports are the department's letters to the court. Section 24 reports are court investigations. And then they talk about the official records of the Department of Children and Families. A court evaluation, a court clinic evaluation, is something that's court ordered by the court for a parent to go to the court clinic at the courthouse and to be evaluated by that court clinic. In this case, it was a parenting evaluation. That is not, there's no exception either by statute or to the hearsay rules for those evaluations to be admitted into evidence.
So your brief relies on adoption of Seth for your argument that that was inadmissible. But as I read adoption of Seth, it seems to turn on the potential that privileged communications with a psychotherapist had been included in or relied on by a psychiatrist in his testimony. I don't see that argument here. So I'm not seeing what there is in Seth that supports your argument. That this
Your Honor, I think that I should have said C's or kind of inferred it's a parallel. I'm trying to parallel to the court. I did not cite it properly in terms of it should have been cited differently, but Seth, I rely on in terms of it's a parallel argument to this, that this is a document that's being presented to the court for the purposes of the truth of the matter. It is complete and total hearsay, and therefore, based on the fact that it's complete and total hearsay, it should not be admitted. This person didn't testify in the hearing either. She wasn't cross-examined. Now, again, trial counsel could have done that, but that's not the issue here. If the issue is whether or not this document should have been admitted into evidence by this court, it's a pretty extensive document, and it's admitted twice as well.
Well,
But
mom's
it's
counsel
still
at
hearsay.
trial, sorry, excuse me. Mom's counsel at trial used parts of this to mom's advantage, but on cross-examination of both mom and the ongoing worker, when she brought out that the parenting evaluator had found that the mother had been a strong advocate for one of the children in getting her allergies diagnosed. So is it possible that mother's counsel made a strategic decision to let this come in?
Your Honor, that's a fair assumption. However, we can use any document, we can use any evidence, any document, any information that we have to cross-examine a witness. It does not have to be entered into evidence. So she could have looked at this document and used it for cross-examination purposes, but this was not the author of the document that was testifying. It was a social worker, and she was just using a fact that she received from a document in order to do her cross-examination.
So back to the question of waiver, you refer to the substantial risk of miscarriage of justice standard in your brief.
Yes.
You didn't cite a case that applies that in the child welfare context, and I looked for cases and couldn't find any. Do you know of any?
No, Your Honor, you're correct. There isn't, but I do parallel the criminal law in that issue, and that's what I cite. I cite Commonwealth versus Clark, Commonwealth versus Tremblay, Commonwealth versus Welton, and Hubbard. And I cite those, Your Honor, because I do believe that there is a parallel between criminal cases and termination of parental rights cases.
Well,
in
one
regards-
parallel that's been recognized is that there's a potential ineffective assistance claim, which we can't evaluate necessarily on this cold record, but which usually proceeds through motion for new trial, as you know, with affidavits, perhaps from counsel about why she did what she did at trial, and some proffer that she was prejudiced. So that's been recognized as a potential remedy. But I don't see where any exception has been made to the waiver doctrine that really applies in all civil cases.
Yes, Your Honor, that's correct. There has been no, there's been no case law in that area in care and protection cases or termination of parental right cases. That is absolutely correct. And that's why I bring it to the attention to the court that, TPR cases are very difficult cases for all of us. And I've been trying them for 32 years in the juvenile court system, as well as in the probate and family court system. And what I can say to you is the worst sentence any court in the Commonwealth of Massachusetts can render is that of termination of parental rights. As we don't have a death penalty in Massachusetts, and even those who are sentenced to life in prison without the possibility of parole, they can see their children. But parents who have rights have been terminated cannot see their children. So I would say to you that in terms of this being an extremely important issue for the court to address, when courts are, in this case, the specific court, really turned a blind eye and relied on this deluge of inadmissible evidence to terminate mother's parental rights. I think the court needs to look at this and review it as, is this a gross miscarriage of justice, Your Honor?
And so we're looking for best interest of the child. And
yes, Your Honor.
Isn't there record evidence that the children didn't want to see mom? And isn't there record evidence that they're thriving now more so now that they're not seeing mom than they had been?
Okay. In response to your first question, Your Honor, those were statements made by the children, allegedly made by the children, and I'm going to say that, to a third party and a fourth party. So the children allegedly said that to a foster parent who was the pre-adoptive parent. So I think we need to look at the weight of that. Said it to the social worker who was appointed to this case after mother's, the goal of adoption had been decided upon by the department. And these statements by the children did not start to occur until after, if we're even going to take them as true, did not start occurring until after the children had been told that they were in a pre-adoptive home and that
Counsel,
they were,
what about
their
the
goal was adoption,
October-
that they were not being returned to their mother. I'm sorry. Justice
Sorry,
Grant.
I see your time is running low. My sense of the judge's findings and rulings here was that they were focused on the domestic violence. Based on the October 2018 incident alone, and the judge's findings of credibility or lack of credibility about the mother, wouldn't that alone have been enough grounds to find unfitness, and that the best interest of the children was to terminate the parental rights?
Your Honor, okay, to take the October 2018 alleged incident, there's no alleged incident of domestic violence between mother and father that day. There's an allegation that, well, there's
It's an
statements
ongoing contact or relationship.
right. There's no evidence of an ongoing contact or relationship. There's evidence that father entered mother's home. The police reports say the same thing. There's no evidence in the record, either in police reports, if we're going to use them, police reports, DCF records, anything, that there was any other evidence other than that which was taken by the police into evidence that father had clothing, pants, shoes, any kind of his belongings in that home. So it is fair to, can be fair to say that father just ran into her apartment, like ran to her door. He could have been in that area stalking her, but there's no other evidence after October 2018 either, that between October 2018 and the time of trial, October 20, mother had any contact with the father. So you have another 2-year period where there's no evidence in this court that mother and father had any contact, Your Honors.
I see
there's-
that's your time.
Thank you.
Any other questions from the panel? Thank you very much,
Thank you.
Attorney Bernardi. As
Thank
between Attorney Cuddle and Attorney Sullivan, you may have told me who's going to go first, but I forget. I apologize. So who's going to go first?
Well, Your Honor, the department will go first, Your Honor.
Thank you.
Your Honor, William Cottle for the Department of Children and Families. Before I begin, I asked the court to let me know when I have 1 minute left of my argument. The department's
Do
asking.
that. Can you not see the clock? Is there a clock on your?
I'm actually, I'm blind, Your Honor. I apologize.
Okay.
Okay.
So you're at 7:42 right now.
Thank you. So the department is asking this court to affirm the trial court's decision terminating mother's parental rights and finding her unfit, and importantly, approving the children's adoption plan. I want to cover 2 specific issues. I'm happy to cover the evidentiary issue, but I want to really focus on, as Justice Grant pointed out, the focal point of the trial court's decision in this case is based on the overwhelming and pervasive evidence of the violent domestic relationship between mother and father starting in 2012 and continuing up and through October 2nd, 2018. In this case, unlike some cases, Your Honors, mother did make efforts to participate in services. The court actually made a finding to that effect. She participated in parenting classes, anger management classes, domestic violence classes. She attended most, if not all, of the services that the department asked her to do.
However, didn't she improve? Didn't her conduct improve as a result of that?
No, Your Honor. I mean, sporadically, the court found it for a couple of visits. She behaved herself honestly, but mother never understood or presented the information to prove to the department or to the trial court that she understood the damage and the harm, the potential harm that could come from this domestic violence relationship with the father. It's clearly, the court found that mother's grievous shortcomings interfere with her ability to care for these children now or in the future. And that's That's what this case is truly about. And mother, aside from all the evidence of the police incident reports with respect to mother 2016 going forward, 2017, and then the October 2 incident, where it's incredibly important to realize and to focus on the fact that the police found a loaded handgun underneath the children's mattress in mother's home, found $8,000 or approximately $8,000 in money, all kinds of drug paraphernalia, and mother testified. Mother here makes a point of saying it's not a lot of testimonial evidence. There's significant testimonial evidence to the relevant points. Mother said to the court that she didn't believe her children would be at risk if they had been placed with her from the beginning of the case. And that statement by the mother, which the court found to support the overwhelming and dispositive point that mother cannot keep these children safe. These children have been, this case went on for 3 years. And in 2015, there was an earlier care and protection case. These children have been waiting a very long time to find permanency, and they have permanency in their present home. Just to make a small point, mother's counsel said that the children didn't have concerns about interacting with mother until they were placed in the pre-adoptive home. That's not true. The facts and the court found in December of 2018, the oldest child, Kay, was asking to maybe take a break from visits because her behavior was totally inappropriate with her children, with the department staff. She was aggressive. She was harsh with the children. She was sabotaging. There's evidence that she was sabotaging their placements with their foster parents. Those findings are not challenged by mother. The findings about mother's overwhelming contact with the father for domestic violence are not challenged by the mother. With respect to the evidentiary issues, again, it's incredibly important to keep in mind, counsel for mother made no objections to the evidence coming in that question. They're not the majority of the findings, but contrary to mother's position, the hearsay information contained in the court reports and the department reports have been clearly found to be admissible under adoption of Luke and back to George. What the Luke doctrine says is that the hearsay that are contained in reports is admissible, subject to cross-examination of identifiable sources, which there were in this case.
But some of the, Attorney Cuttle, this is Judge Sachs, some of the hearsay evidence that the mother objects to now is nested hearsay by the children themselves, statements by the children themselves that the judge seemed to admit for the truth. You're not suggesting, I don't think, that the mother could have called the children in as witnesses in this trial.
No, I'm not suggesting that, Your Honor. I'm suggesting that if the mother had questions about the reliability or credibility of statements, the mother could have called the department workers or the therapists, and it would have been the trial court's decision to decide whether the test, the record evidence was reliable. That's the whole purpose of admitting these documents.
Right, but that takes care of one level of hearsay. But to the extent that those documents in turn rely on other hearsay statements, as they often do, then to satisfy Luke, those other witnesses have to be available for cross-examination, don't they?
Sure.
I believe so. I believe that Luke doesn't differentiate between the sources, whether they're adults or children.
Right. So every level would have to be, every declarant at every level of hearsay would have to be available. And I get your argument that the main issue here was domestic violence, not necessarily the children's exposure to sexual material, but the judge did credit the children's allegations expressly, and I don't know how the mother could have met that argument without calling the children as witnesses, which of course she would be extremely reluctant to do. And the court might prohibit it.
Counsel. Sorry, Mr. 20 seconds. Judge Sachs.
Is there-
50 seconds. I apologize for speaking.
Your Honor, the department stands by the adoption of Luke's standard. I want to just point out that the court uses the term either experienced sexual abuse or was exposed to. I think that's a little bit confusing. The children in this case, and the children's attorney points this out in her brief as well, the children both reported in a SANE interview that they were not sexually abused by mother or father. It has to do with their exposure. The court made ample findings about the children's behaviors, sexualized behaviors, and all of those factors were considered by the court properly.
Final question. Is there any record evidence to the unavailability of any of the names or the clinicians who are named in the documentary evidence?
Could you ask me that again, Your Honor?
Sure. In order for it to come in, some of these hearsay statements, the source has to be identifiable. And they
Yes.
have to be available. Is there any record evidence that some or all of them were not available?
No, there isn't, Your Honor. And even in with just to briefly comment, even on the court clinic evaluation, everyone agreed to that document coming in, that evaluator was available. Mother chose not to call that evaluator. And the department's position is since no objections were made, all that information was admissible to the court. She waived her right. If there's no other questions, I'll rely on the department's brief.
Thank you, Attorney Covell. Attorney, let me just ask my panel, any additional questions? Attorney Sullivan.
Thank you, Your Honor. If it pleases the court, my name is Ann Sullivan, and I represent the children in this case, K and J, two young girls. They're asking the court today to uphold the finding of fitness and the termination of parental rights so they can be freed up for adoption as quickly as possible. I'd like to go back to for a minute to this issue of sexual abuse, what it is in this case, and also what findings and conclusions the court did or did not make. My sister, representing mother, said that the court concluded that there was sexual abuse in this case. The court did not make that conclusion. I refer you to finding 19 and 20 of the court, wherein, if I could have 1 minute, and I'm sorry, also, the court explicitly says and cites case law that it did not have to make a finding of sexual abuse, and that in fact it made a finding under the standard of more likely than not. In other words, a preponderance of the evidence. The court explicitly said it did not draw a conclusion of sexual abuse. Secondly, Your Honors, what is sexual abuse in this case? And I think it's somewhat confusing because we're looking for, well, is there sexual contact? It says no in the findings, but it says maybe yes in the conclusions. In the conclusions, number 16, the court refers to sexual abuse in this case as disclosures made by the children as to what they had experienced or what they had witnessed. That's what sexual abuse is in this case. There's no suggestion in the conclusions that it's contact. In fact, there's a finding in the case that it is not contact. So here we have sexual abuse as the children being exposed to pornographic materials and hearing parents having sex. Now, the court was entitled to rely on the children's statements. Because some of these statements went to the children's state of mind. They were also entitled because there was no objection. But in the end, Your Honor, it's not central to this case. And in conclusion 4, the trial court says sexual abuse is not central to this case. As my brother pointed out, what is central to this case is ongoing domestic violence between the parents. Another point I would like to make is that when the court mother says that the children only asked to be separated from, and that they didn't want to see mother after they were placed in the pre-adopt home in March of 2019. As my brother pointed out, the children began distancing from mother back in December of 17. Kay wanted to take a break after mother yelled at her. In January of 2019, Jay no longer had phone calls with mother. In the spring of 2018, Jay no longer had phone calls with mother. January of 2019, Kay's phone calls stopped with mother. In March 2019, when mother manipulated Jay by telling her to tell DCF that she didn't want to be in the pre-adoptive home and it was their, would be their secret, Jay was afraid to divulge that secret because mother would whip her. And after March of 2019, the children no longer wanted to see mother. They were actually placed in the pre-adoptive home in April. So I think it's clear that children didn't want to see mother, and that the court could properly rely on these statements because it went to children's state of mind, what they were thinking about mother, and what they were thinking about living with her. I'd like to say that in addition to the issues around domestic violence, which was central, there were also the other parental deficits that mother had: her volatile temperament, her poor judgment, her lack of parenting skills, and the court properly considered these parental deficits in the cases Adoption of Mary, 414 Mass 795, 1993. And these deficits harm the children, which I'll speak of, and also how they would continue to harm the children if the children returned to mother. From the beginning, and visits, although mother says the visits were wonderful, it was abundantly clear that mother was acting inappropriately and sabotaging the children and manipulating them. The very beginning, she coached the children. She told them to disrespect the foster parents. She told them DCF weren't good people. She stomped her feet at visits. She used profanity against DCF. She disregarded DCF's rules. She tried to give them a phone. She did give them a phone, even though DCF said not to. She whispered to them. Against DCF rules, she took them into the bathroom unsupervised. And she discouraged, in phone calls and at visits, she told them to act bad and disrespectfully to the foster parents. And she told them in November 2017 that we were returning with father. These things harm the children. And after visits, Kay was upset, emotionally dysregulated, and her school teacher reported that. Again, in December, Kay wanted to take a break. She couldn't take it. And both the children didn't want phone calls. They had to be treated for post-traumatic stress syndrome. They struggled. Now, as my brother pointed out, mother participated in services and the court gave her credit for that. However, at the visits, the same behavior continued. Her relationship with father continued. And even with her substantial compliance, even if she had substantial compliance with her service plan, which the court found she did not have, the court may still find that there's a failure to address parental deficits. And that is the case here. The site for that case is a Home for Little Wanderers, which I'll provide the site if you'd like. In April 2000.
I see that your time, counsel. Let's see if the panel has any additional questions. Hearing none, I think we're going to have to leave it at that. The matter stands.
Okay, we are live and on the record.
Thank you. So good afternoon. My name is Judge Desmond. With me is Judge Sachs and Judge Grant, and we'll be your panel for this hearing. This is the matter of John Doe number 526197 versus the Sex Offender Registry Board, docket 2020 P0998. As you know, 15 minutes per side with no rebuttal. We've read your papers, we're familiar with the arguments, and so perhaps the best use of your time is to get right to your arguments, but I leave that to your final decision. I believe it's Attorney Green for Mr. Doe.
Thank you, Your Honor. May it please the court, I'm Ashley Green representing Mr. Doe before you today. I would like to start off by asking this panel to remand this case back to the board due to a culmination of errors. The appellant specifically is requesting an order that the application of Factor 2 be stricken from consideration and that the hearing examiner's abuse of discretion in misrepresenting the facts, when this is remanded, that is noted for further review in this case. We are also, I'm sorry.
It's true that Doe was charged for acts committed on Janice. You agree with that?
He was charged, correct.
Okay, and isn't that what the statute calls for?
So the difference in this case, and this is where it gets into the abuse of discretion that the hearing examiner created or used, is that 2009 charges that Your Honor is referring to, those were not just dismissed for lack of prosecution, as the hearing examiner noted. They were actually dismissed after a probable cause hearing was held and no probable cause was found.
I understand, but that doesn't mean they were any less charged initially. Is that fair to say?
That is fair to say, Your Honor. That is,
okay. And when the court found no probable cause, they specifically noted that was because the alleged victim didn't testify. So it wasn't as if she or the judge or the court assessed the weight of the testimony. There was no testimony at the probable cause hearing, right?
That is correct. However, the court could have taken into consideration the police reports and the other evidence, finding credible evidence elsewhere. But instead, the court, after a probable cause review or hearing, found that no probable cause existed to bind the case over to the Superior Court.
Because the victim failed to testify.
In addition to that finding, the victim also failed to testify, correct?
So you're saying that because the judge in ruling on the probable cause hearing could consider hearsay evidence, including police reports, the judge should have found probable cause knowing that the victim wasn't cooperating and sent the case down for trial without a victim?
My argument is that if the case had enough credible evidence to support the allegations, the judge would have found probable cause. And in this case, the judge didn't find probable cause because there was no credible evidence. These were pure allegations.
Did any judge ever make a finding that the victim was not credible?
Not before hearing from the victim.
At any time?
Not without hearing from the victim.
The victim not only didn't testify, she invoked her right against self-incrimination, which was a pretty good indication that if the judge did find probable cause based on the police reports and so forth, the victim wasn't going to show up at trial where those reports would have likely been inadmissible. So can we really conclude that the judge didn't find there to be, can we conclude that the hearing examiner basically couldn't rely on the charges and the victim's original allegations to find that the conduct had occurred, even though the judge dismissed it?
I think the argument is that the hearing examiner abused his discretion in finding that 2009 allegation was true and basing his opinion on that.
And the hearing examiner looked at the police reports, the complaints that were made to the police, as well as some what I'm gonna call contemporaneous journal notes that Janice had taken around the time of these offenses that seemed to be consistent with some physical injuries that she suffered at that same time, right?
My understanding is that the actual journal entries were referenced, but the hearing examiner did not have copies of those journal entries.
But that brings me back to my initial point, which is the statute calls for them to have been charged, and Doe was charged. So how is it? So I mean, I understand the argument that it's an abuse of discretion, so I don't want to say I'm not hearing you, I'm hearing you. But when we're looking at the statute, what about it is not on the record? Or what? Go ahead, I'm sorry.
What I take issue with is that the hearing examiner made an error in finding that this case was dismissed for lack of prosecution. That is not true. That is an error. And that error included in this decision allowed the hearing examiner to then go on and say that he fully gave credit in all of the allegations made in those 2009 offenses. And that's an error. That's not what happened.
So the Commonwealth could have elected to just not move for probable cause.
And
right?
charge in district court?
Or just once the victim got a lawyer, I believe the victim had a lawyer, invoked her right, the Commonwealth could have said, well, we're not going to move for probable cause, we'll just dismiss now. And would you say then we wouldn't be able to consider that?
I wouldn't speculate on that because that's not what happened here.
But aren't there cases saying that police reports are sufficiently reliable hearsay that the board hearing examiners can rely on them even if a prosecution, never mind a conviction, didn't follow?
It is preponderant. The subsidiary findings are preponderant to the evidence, you know, things that are normally relied upon in the normal course. And in this case, it could have been relied upon. Again, I take issue with the hearing examiner's misunderstanding and misstatement of what happened, and
Okay.
Not actually.
There was a misstatement. Happened. There was a misstatement, but was your client prejudiced by it? If the hearing examiner had said the charges were dismissed for lack of probable cause after the victim invoked, we would be in the same place, wouldn't we?
We wouldn't, because I think that's a different scenario, to be fair. I think that the hearing examiner saying that it was lack of prosecution, he kind of just said, well, they were dismissed, but I still fully believe the victim entirely. The fact that the victim refused to engage and invoked her fifth, and then there was no probable cause found based on that, I think that it's a different set of circumstances. And I do not believe, the hearing examiner needs to find it by a preponderance of the evidence that occurred. And at that standard, I don't think it could be applied and met in this case.
Aren't there cases where acquittals, the evidence has been found sufficient, even though the matter resulted in acquittals?
I'm not aware of acquittal cases being upheld as subsidiary findings, but there certainly could be.
I want to make sure I understand your factor 2 argument apart from this distinction between lack of prosecution and lack of probable cause. Do you agree that the decision by Judge Wilkins in the Superior Court regarding factor 2 didn't completely invalidate factor 2, but rather said that it can't be applied where there's no confrontation or investigation or prosecution in between the first sexual conduct or misconduct and the second?
I believe that this honorable court has interpreted Judge Wilkinson's decision in that way, and saying specifically when there is a case of confrontation, factor 2 can be applied, and when there is no confrontation, it cannot be applied. Yeah.
Okay. All right. So assuming that we were to not agree with your argument about probable cause versus lack of prosecution, then factor 2 could be applied notwithstanding the Judge Wilkins decision. It's not completely invalid.
I believe that's what this appeals court believes. My argument is that factor 2 should be completely invalid because the board has been applying it erroneously and not in line with the research and the studies that have come out about factor 2.
Well, Dr. Hansen says if you've got somebody who's confronted or charged and then they offend again, that's a problem. Isn't that what the board or the hearing examiner did here? How is that not consistent with Dr. Hansen's testimony?
Because our overall argument is that the 2009 offense did not occur. It was a domestic dispute between a girlfriend and boyfriend, and there were allegations made that were unfounded. And so that is our argument. And therefore, if you don't have the 2009 offense, charges, confrontation, it was wrongful accusations.
And so you would say that if we set aside the incident with Janice and just looked at the incidents, plural, with the daughters, then that wouldn't be sufficient. I think your brother argues that alone's enough to support factor 2.
That's correct. That's correct. My argument is that the 2009 allegation should not have been in consideration, and therefore the index offense for which my client was convicted or pled guilty, that is the sole episode of sexual offending that's occurred, and therefore factor 2 cannot be applied.
But weren't those multiple episodes?
Multiple episodes without any confrontation intervening between the episodes.
And time alone to reflect is not enough.
Time alone to reflect is not enough.
I want to ask about your argument that the hearing examiner erred by not assigning weight to each factor. The Superior Court judge seemed to have some sympathy for that argument based on Justice Wolahojan's dissent in Doe 291554 back in 2015. But that was a dissenting opinion. That's not the position of the court. And so to agree with your argument, wouldn't we essentially have to reverse the result in that 2015 decision?
I think it would be giving, well, I think in light of the fact that the hearing examiners are continuing to fail to give any sort of specific weight to majority of the factors, I don't think it would be reversing the decision. However, I do think it will be giving a clearer order to the hearing examiners that there has to be some way to conduct a meaningful review of these decisions, especially when these decisions are being issued by a number of hearing examiners that are coming from all different backgrounds. And I don't want to get into another argument about the requirements of a hearing examiner and what they do to get into those positions. But because there's so many different decisions being issued and there aren't any weights assigned to each factor, the ability to review and to see how much each factor is being given is almost impossible for any court to review it.
So I understand that as a policy argument, but on these facts, what if we were to say, okay, those factors where the hearing examiner did assign weight, the most weight, the aggravating factor, did consider the sole mitigator, and we were to say, given the hearing examiner didn't articulate what weight, we give them all the minimal weight. Wouldn't that still be enough to support a level 3 finding on these facts?
On these facts, given that this is a sole episode of sexual offending, I don't think that this appellant is a level 3.
I'm sorry to interrupt you. You say sole episode, but it was two victims over a period of time, and we need not get into the facts.
I use episode probably loosely. It was a time of this appellant's life that there was offending that occurred, yes. And to answer your question, if we gave them all the minimal weight, then no, I don't agree that he would still be a level 3 offender. In this case in particular, just to highlight why it's important to give weight, is factor 2 was given the most weight in this case, or as I would say, the highest degree of weight. And if we do go back and we strike that from this decision, that changes the whole analysis of reaching the ultimate conclusion that he's a level 3.
The way that the hearing examiner gave factor 2 maximum weight, because factor 2 itself specifies how weight is to be given in various circumstances. And likewise with factor 19. But the other 8 factors that you cite as not having been given any particular weight do not say give X weight if these are the facts, give more weight if there's some other facts. So where the factors themselves don't specify how they should be weighted, why is the hearing examiner nevertheless required to assign some kind of weight?
Well, unfortunately, the board writes their own regulations, and so they have all the power here. The appellant does not. And so if the board's going to write their regulations like that, we are powerless except to come before your court and ask that there be a change to the system, that they're requiring these men and women to register as sex offenders, which, in this case, yes, there are some factors that lay out it should be, threshold, moderate, or high degree of weight. But majority of the factors don't have that. A large majority don't have that, and they easily could. There's such an easy way to go through and just say, okay, there's 3 victims that gets a higher weight, or what have you. But they're just certainly not doing it here. And because of that, we don't know how they're reaching their ultimate conclusion. And there's a lot of language that's being plugged into these decisions that doesn't really say anything.
So,
there needs to be more
I'm
of a
going to interrupt you
systematic
for
way.
1 second. I'm going to interrupt you. So given that, and then I know Judge Grant has a question, but given that, then how can we say the hearing examiner erred
The hearing examiner
by not assessing weight?
Because their findings because I could simply just come before you and say that the culmination of these factors does not reach a level 3 if I assume that they're all given the least amount of weight.
Judge Grant.
That's the only, there is no other argument.
I have a question about the internet dissemination issue and your request for remand. What would we be remanding for evidence to be brought forth of? And can we consider the fact that your client has an extensive III with out-of-state non-sexual cases? Does that give us more reason to order internet dissemination?
So the issue in this case with internet dissemination is that the hearing examiner did not connect all of those findings that would be necessary to require internet dissemination. And as Your Honor stated, my client does have a record, and that's not something that we can hide. However, it's not up to the hearing examiner to determine whether or not my client has a record or whether he's going to commit another criminal offense. It's whether my client is going to commit another sexual offense. And in this case, where the research shows incest offenders are less likely to offend against a member of the public, it is less necessary to have him on the internet. And so those are findings that need to be found by the hearing examiner. And in this case, unfortunately, despite DOE 496501, they were not found here.
Not because this case preceded that.
This case preceded that, and therefore that's why we're asking for a remand now that the hearing examiner and the board is well aware of the court's findings in DOE 496501. They will issue either a different decision or a better and well-reasoned decision.
One final question about the internet. At the hearing before the board, Doe's then counsel argued that he should be classified as a level 2, which at that time and today would have led to internet dissemination. Can we take that into account in deciding whether a remand is necessary here?
That was certainly included in the classification hearing transcript, and that can be taken into consideration by this court as part of the record. For sure, it's not evidence of anything, but it was an opinion statement. And to be fair, my clients generally have a very hard time lowering their level. And so if we can get my client to a level 2, even though it includes internet dissemination, then he will be in a much better place in life going forward in order to get out of the hole that he is currently in. So yes, that can be taken into consideration.
Attorney Green, thank you very much. I see that's your time.
Thank you, Your Honor.
Attorney Boss.
Yes, Your Honors, good afternoon. May it please the court. My name is John Bosse and I represent the Sex Offender Registry Board. I just want to be clear that it's the SORB's position that Factor 2, based upon the sexual misconduct of the plaintiff against his 2 minor daughters alone, wouldn't apply in light of the Superior Court's declaratory judgment.
Now, why do you say that, given there was no challenge or confrontation in between the episodes, although there was time to reflect?
Right. So, well, we say that because the declaratory judgment is binding on the SORB, and my memory is that because this case is still pending, the declaratory judgment would be binding on this decision, because this case is still pending. So it's the SORB's position that Factor 2, however, is still applicable based upon the mere fact that the appellant was charged in 2009 with a felony. He was charged with rape against Janice. And despite being charged with that rape, he sexually reoffended in 2016 against his minor daughters. And that's what Dr. Hansen has stated is relevant. So when you look at this court's 2019 decision in 22188, which I cite in my memorandum, in my brief, as well as in my supplemental memorandum, this court did a nice job of summarizing what Dr. Hansen's testimony was regarding repetitive and compulsive behavior. And in summary, Dr. Hansen said, repetitive and compulsive behavior is a problem when a person is confronted, charged, convicted, and yet they continue to sexually reoffend. So even if this court were to find that the police reports regarding the sexual assaults against Janice do not contain a sufficient indicia of reliability, my argument is, and I'm not conceding that at all, but my argument is the mere fact that he was charged with the serious felony, a sexual offense in 2009, and he went on to sexually reoffend in 2016. That's what Dr. Hansen would find is relevant, and Dr. Hansen, I believe, would say that Factor 2 is then applicable.
Are you saying Dr. Hansen would find it relevant even if the person had not actually offended? So a false accusation is enough to put someone on notice so that if they do actually commit their first-time offense sometime in the future, that first-time offense is repetitive and compulsive because somebody falsely accused them in the past?
Your Honor, I can't put words into Dr. Hansen's mouth, but that's been my position for a long time since I've been with the SORB, is the fact that somebody has been charged with a sex offense, even if, like you said, the charge was dismissed because it was found that the victim was incredible. The fact that they charge and continue to reoffend, I believe Dr. Hansen would find that relevant and would say that Factor 2 applies. But as we know in this case, it's SORB's position, based upon reading the criminal complaint as well as reading the docket sheet from the Leominster District Court in 2009, that the only reason why the Commonwealth didn't move forward with this sex offenses regarding Janice is because the court found no probable cause because she decided to not testify at the probable cause hearing after invoking her right against self-incrimination. But then, of course, there was also the police reports in which there was an indicia of reliability that the plaintiff sexually assaulted Janice on 2 separate occasions in 2008 because she detailed to the police what occurred. She kept journal entries of at least one of the sexual assaults that occurred on December 12th of 2008. And furthermore, under decisional law, you can consider that the subsequent sexual misconduct against his 2 daughters corroborates that he committed a prior sexual assault against Janice because it shows that he is a contact sex offender.
If she's invoking her right against self-incrimination, should we infer that she was lying?
Right. So that's a great question and something I thought about, but we cannot speculate at this time as to the reason why she invoked her Fifth Amendment right against self-incrimination. We could easily, just as easily speculate that she invoked her Fifth Amendment right on the grounds that she assaulted him first on December 12th, because in her journal entry, she wrote that I saw him kissing another woman, and as a result, we had a fight, and then during the fight, he got aggressive with me, and then he sexually assaulted me. So we could easily speculate that her Fifth Amendment was that she was the aggressor, and that he continued with the fight and then sexually assaulted her. But yeah, I guess in summary that we just don't know what her Fifth Amendment was based upon the docket sheet. And I think Attorney Green, in a couple of briefs I've had with her now, she makes an interesting argument about the weight, or in this case, the lack of the hearing examiner didn't explain the weight that she applied to a number of the regulatory factors. However, in Doe 22188, this court did say that a hearing examiner's decision will be deemed arbitrary and capricious if they fail to consider the regulatory factors that are relevant to a person's to a person's risk to reoffend. They said what weight, if any, should be given to the regulatory factors. They expressed no opinion. So I believe this court has answered the question that as long as the hearing examiner considers the regulatory factors that are relevant in the case, the hearing examiner need not explain the weight that they give to the factors. And we do cite that case in our brief. And unless the court has any further questions on that, I will move on to the last issue of internet dissemination. In this case, we believe that we're asking the court to not remand for internet publication because there is substantial evidence to support the level 3 classification. Even if you take out the sexual misconduct against Janice, you still have a plaintiff who sexually reoffended against 2 minor girls, his daughters, in 2016. He has a history of general criminality, and also 3 different women, including Janice and including the mother of the minor girls, have taken out restraining orders against him. So we believe that because substantial evidence supports the level 3 classification, internet publication is justified, and that it will protect women and minor girls from possibly becoming victims of sexual abuse. I see that I have almost less than 6 minutes, unless I know it's been a long morning for you guys and a long afternoon. Unless the court has any further questions, the SOAR will rest on its brief and supplemental memorandum.
Anything additionally? I think that's it, Attorney Bossy. Attorney Green, thank you very much.